Thank you. 10-4.
We have separation. She's right.
Hey guys, good evening. Thank you for being with me here tonight. Tomorrow we have a hearing Wednesday. So tomorrow's hearing is at 9. We'll go on at 8:30. Wednesday there is a hearing at 2. There is actually a hearing in federal court as Karen appeals the SJC decision regarding counts 1 and 3. I don't know if that's streaming anywhere. I won't be streaming that Wednesday if it is. But we will be streaming the hearing that takes place at 2. Turtle Boy has a hearing in the same courthouse at the same time. We don't stream the Turtle Boy hearings anyways. And then Friday, there'll be a hearing at 9. And I will be here to start that hearing. And then Kate or somebody else, whoever's available, will be here to take it over. But definitely we'll be on. We'll cover all 3 of the Karen Reed hearings. Now, today I wrote yesterday my stab at an opening statements for this case. I should have gone back to see how my opening statements had changed from the one I did last year. And who knows, I'll probably do another one before the trial starts. I ran into a problem where when I try to put it on, I use this program it's a free program called Q Prompter. And every once in a while, it's done this before where when I go in there, it must try to access my camera and my mic, and it shuts. So it takes me off the StreamYard. So what I have to try to do here is I put this on a backup laptop, and I'm probably going to try to cover this here, and hopefully it won't cover the camera, and do it from this. Just trying to adapt to what I can do, and still, because this is written, so I'm reading this from a teleprompter. It's not real long. I think it's probably take about 10, 15 minutes to read. So let's give it a shot. Hopefully I'm not blocking everybody. All right, so hopefully, guys, you should still be able to see me. Might be a better thing to not see me, right? But hopefully you still should be able to see me. All right, so again, I'm not a lawyer. I've tried to comply with the law as much as possible. I've researched it, but I'm sure there's a lot of areas in here where an actual lawyer will say, no, you probably shouldn't do it that way. And the things that you're going to put forward in an opening statement do have to be things that are already in evidence and will appear in the trial. So there's one or two things here that I know are in evidence that were not used in the last trial. So I'm speculating that they will be used here. There's nothing new that you haven't heard me talk about before. All right, so let's begin. Nuts and bolts. Nuts and bolts evidence will be presented to you which proves beyond any doubt that the defendant's vehicle struck her boyfriend just seconds before his phone last moved. Her words. The defendant's words at the scene, coupled with her strange behavior, shows that she understood the consequences of her actions. The timeline. The timeline will show that even if the defense presents some wild scheme suggesting the defendant was framed, there was no opportunity to tamper with the vehicle until after its taillight pieces, as well as the victim's shoe, were found buried at the murder scene under 3 feet of snow. That's how the timeline works. No one is saying that planting evidence doesn't take place somewhere in the country. No one is saying that police corruption doesn't exist somewhere. The timeline just doesn't allow it in this case. So in order for you to do your sacred duty here, you will have to tune out a lot. You'll have to tune out the noise from outside. The defendant, not trusting in your judgment, chose a PR strategy, media and social media, but the public has not seen all the evidence. You will. You'll have to tune out the noise inside as a defense tries to distract you. Everything from butt dials to phantom stares to, yes, even ghosts. Your job will be to place these distractions in their proper place while you examine the fundamental evidence. The evidence will prove that the defendant, heavily intoxicated, drove her boyfriend to an after-hours party just hours before a historic blizzard would strike. She's told various versions of what happened, but the evidence will show that he got out of the car, she started to drive forward, then, seemingly in a fit of rage, punched the gas in reverse for several seconds. Her 6,000-pound SUV clipped the victim, knocking him in onto his head and rendering him unconscious. The cold finished him off, slowly, because she did not call 911 and did not return to the scene until hours later. There is no video recording of the moment of impact, but there is something just as solid. It will require you to listen to a couple of minutes of explanation, but don't worry, we won't ask you to do any calculus. When you watch a video of something, you trust your eyes. But when you see the irrefutable data we're going to show you that proves the collision, you'll have to trust in your ordinary common sense reasoning. Don't worry, nothing more complicated than 2 plus 2. I'll come back to this in a moment. The physical evidence will show that pieces from a taillight were found in a debris field near where the victim was discovered unconscious and unbreathing. Once those pieces were reassembled, they were matched to the missing piece from the defendant's vehicle. Various videos of that vehicle from throughout the day will show that her taillight was missing those pieces. The earliest caught by a Ring camera at 5:08 in the morning as she pulls the vehicle out of the garage where it had been parked after the crime. Several witnesses will describe that vehicle as missing those pieces. The defendant herself will describe it. An interview she recorded with a reporter revealing that she herself examined the taillight early in the morning and, seeing these missing pieces, even plucked one out. Those taillight pieces, along with the victim's shoe, were plowed into the gutter early in the morning. 2 more feet of snow would fall on top of that plow bank. The pieces, along with the shoe, would be dug out later in the day by a 7-man state police team, shoveling out an area the size of only 2 parking spaces. From the time the vehicle pulled out of the garage at 5 that morning, during the entire day, it was either parked under video surveillance or the defendant herself was within it. Later in the day, the state police towed it from her parents' home over an hour away. As it was arriving at a police garage, the state police and WBZ News were already set up at the crime scene, and within minutes would begin their work. 9 minutes after the tow truck brought the vehicle into the garage, the Special Emergency Response Team, troopers which had come from all over the state, found the corner piece of the taillight buried 3 feet down. Minutes later, they found the shoe buried nearby. This isn't a complicated case. In desperation, the defense will attempt to make it so. They'll suggest that the victim went inside the house. However, GPS will show that he never went inside the house or even near the house. His phone was found underneath him at the far edge of the property, a few feet from the street. But let's go back to the simple evidence that establishes precisely when and where the crime took place in a way which can't be refuted. The key concept is this: correlation. The vehicle data from the defendant's car will show two events: a 3-point turn, and then 8 minutes and 4 seconds later, it shows an angry outburst where the car is slammed into reverse for several seconds. 4 seconds into that second event can be seen the telltale signs within that vehicle data of a pedestrian strike. By correlating these events in the vehicle data with the data on the victim's phone, we'll show you how the pedestrian strike happened at 12:32 and 12 seconds, plus or minus a few seconds. And that data also shows this: the victim's phone stopped moving at exactly 12:32 and 16 seconds. That's only seconds after the vehicle data shows the pedestrian strike. Several types of evidence will show that the defendant was very much beyond the legal alcohol limit to operate a vehicle. Video surveillance from 2 establishments shows she consumed numerous drinks. We'll see the bar tab that corroborates this, as does the blood test taken the morning at the hospital. Finally, there's the issue of intent. When the defendant slammed the SUV in reverse, at the very least, she had reason to believe that pedestrians might be on the dark street. Not only were guests arriving for an after-hours party, but she had just dropped off the victim, her boyfriend. And while we can't know for certain if alarms within her vehicle sounded before she struck him, this is a highly sophisticated and expensive vehicle, a Lexus SUV, with advanced sensors designed to detect objects in the path and warn the driver. Was her rage so much that she couldn't hear those alarms? And when she got back to the victim's home, she left multiple angry messages on his voicemail. Indeed, she told her boyfriend of 2 years that she fucking hates him. Before 5 a.m., testimony both from the victim's young niece within the house and from 3 people she spoke to on the phone will show that she now panicked because the victim did not come home. Oddly, she didn't seem to even entertain the possibility that he was just still hanging out at the house or that he'd crashed on a couch. No, she concluded that he was in grave danger, perhaps hit by a plow, she said. She even wondered if he was dead. Why? One thing that she did not do: call 911. And that time was critical. The victim might have been saved. Instead, rescue would wait over an hour from when she claimed he was dead. While he lay unconscious in the blizzard, snow accumulated rapidly on top of him. Now, we believe it's likely she returned to the scene by herself and found John, perhaps believing him dead, she left him there. She might have decided to go get friends so they could find him together. We don't know. You'll have to weigh it. But more crucial time ticked away as she failed to call for help. When they finally found John, the first responders came soon after, and the extreme stress of the moment caused a breakdown in the defendant. The truth spilled out in emotional outbursts. I hit him. I hit him. Multiple first responders will testify to hearing this. The defense, like every defense, will try to distract you with odd things. There are odd things in every human event, in every criminal case. Odd merely means unexplained. The overwhelming majority of odd things manufactured by the defense in this case have ordinary, mundane explanations. You'll hear them. There will always be things in any situation where the explanation remains uncertain. But I'm not here to explain why the Beatles broke up or why pineapple goes with ham on a pizza. While it is the job of a defense team to make the ordinary and mundane seem extraordinary, it's your job to decide if the things they conjure up are actually meaningful. Do they tell us anything about what happened? Or are they just distractors designed to get you to take your eye off the unshakable evidence? Now, that evidence here is simple and solid. When defense teams can't challenge the facts, they challenge the police. But the problem for them in this case is that the evidence, as you'll see, could not have been manufactured, even if multiple troopers, for some unfathomable 6 degrees to Kevin Bacon reason, wanted to. An overview of this case shows that the defendant had too much to drink, dropped off her boyfriend, put the SUV in reverse, then slammed the gas and clipped him, causing him to strike his head on the frozen ground. He never regained consciousness. She never called 911. John's GPS will show he never went inside the house, and 9 witnesses will testify they never saw him in the house. It ain't complicated. I want you to remember the key words. Correlation. The correlation of the vehicle data within the victim's phone data creates a bulletproof record. Timeline. The timeline of that vehicle's journey makes the planting of evidence impossible. The defendant's words, her words, heard by almost a dozen witnesses, reveal consciousness of guilt. Logic, common sense, nuts and bolts. All right, thank you guys. I hope that worked out with my backup computer on top. It threw me off a little bit, but hopefully it provided some value. Now, the other thing I want to go over to, how long did that take? So that took less than 15 minutes. So that gives about an idea. I think these don't usually take a ton of time. All right. Now I wanted to also go over, so our friend Anonymous Mass Lawyer has another excellent article out. So let's go over that. Let me put this on the screen so you can, if you prefer, turn the volume down and read along on your own. Let me just actually, you know what? I should stop and look at your reactions to that quickly and see if there's anything that you guys think that I did bad or could have done better. Your own opinions. Let me just go through the comments real quick and see what you guys think. Six degrees to Kevin Bacon, McDiggies. Let's be clear. Hawaiian pizza is awesome. And it is a mystery, right? It's a strange combination. Yes, the game was a fun movie. Happy says, hey, Kevin, any truth that you have an intimate relationship with a Norfolk County employee? Ooh, that sounds juicy. What's she look like? I said, dude, no. I don't know anybody from Norfolk County. I don't think I know anybody from Norfolk County, let alone the Norfolk County DA's office, but I'm sure I must know somebody from Norfolk County, but I definitely do not know anybody from the Norfolk County DA's office. Thank you, Trevor. Valeska, thank you. Macy, thank you, Jane. So my idea is try to keep it simple. I'm not saying that anybody will take any inspiration from it, but you know, thank you, Jen. You know what? Maybe if you guys want to write your own opening statement and send it to me, I'll read it. That could be kind of fun, right? So if you guys want to write your own opening statement, I won't promise that I'll read it. I mean, if it's, if it has to reach a certain standard of quality, but, and hello, Richard Smith. And thank you, Laura. So yeah, that's actually kind of a cool idea. Why don't you guys write your own opening statement and send it to me? I won't obviously. So it would take. So the one I have there is, I don't know, maybe a couple thousand words. Maybe it's a little less. I think it's maybe. I'll tell you after. Let's see. I can tell you right now. Hold on a second. I added a paragraph to that. So I think it was about 1,600 words, maybe a little more than that. So that gives you an idea. If you want to do your own and you want me to read it, send it. All right, so let's go to Anonymous Mass Lawyer's article. And this is another example of what I say. This is someone who is trying to be objective. He's not going to agree with everything that people on the anti-Karen side agree with or whatever. I mean, that's the important thing. This contrasts quite a bit with the law tubers on most of the law tubers on the other side, who are very one-sided and clearly trying to pander to that crowd. And that's the part that I don't respect. I mean, if you can't at least, like, if you're still running around talking about 227 as though it happened, it's hard for me to respect you. There's been too much evidence now brought to bear that at the very least you should be saying it's unlikely, right? So if you're going around saying the 227 search happened, I can't take you seriously anymore. Not if you've been covering this case for more than a month, All right. This is from Anonymous Mass Lawyer. If you spend any time within the Free Karen Read online universe, you soon see that the general consensus is that the prosecution's case is incredibly weak, that there is no evidence that Reed hit O'Keefe with her SUV, and that only corruption can possibly explain why the Commonwealth is still pursuing this. It's a statement. It's a testament to the siloing of our modern media ecosystem that statements like these can be made by sentient human beings without encountering any pushback. Yeah, there's a lot of it's more in social media, but there are a lot of irresponsible things said in regular media too. If you want to make an argument based on reasonable doubt, I'll listen to it. I've said many times that, well, I think Reed is very likely guilty of vehicular manslaughter. I don't think the prosecution met its burden in the first trial, largely due to lack of quality expert testimony. But it's ridiculous to pretend that there isn't a lot of evidence pointing to Reed's guilt. I get the sense that many of Reed's supporters don't understand that almost all criminal cases, at least the ones that go to trial, rely primarily on circumstantial evidence. In other words, the crime isn't captured on video or observed directly by eyewitnesses. A large percentage of criminals currently serving time were convicted on far less evidence than what exists and against Karen Reed. Let's put aside for a moment, he continues, or she, the various arguments Reed's defenders have constructed to explain away the prosecution's evidence and just consider what types of evidence the prosecution has. Means and opportunity. Clear and incontrovertible evidence, GPS data, testimony of multiple eyewitnesses, Reed's own statements, places Karen behind the wheel of her Lexus at the exact location where O'Keefe's body was later found, at right around the time his phone data indicates he stopped moving. And that's fundamental. Is that beyond a reasonable doubt by itself? It's close, but maybe not. But there's a lot more evidence, as we know. But it's important to establish that fundamental overview that that's what this case is. And that's a tremendous burden for the defense to overcome. All right, many shards of Reed's shattered taillight were found in that same area, right next to O'Keefe's missing shoe, and tiny shards of taillight were found embedded on John's clothing. One of O'Keefe's hairs was found on the back of the SUV, and his DNA was found on the taillight casing. TechStream data was recovered from Karen's SUV that aligns perfectly with the odometer distance of this particular trip and shows a rapid acceleration in reverse that aligns temporarily with John's last movement. Now, I generally have avoided the odometer thing because it seemed like there was still some question about that. Now, that may be matched up much better in this trial, but the questions were about the key cycles and some of that stuff. What we have to understand is that Trooper Joe Paul, had years of experience with black box data, ordinary black box data. But TextStream is within the Lexus is the black box, but then there's an additional storage system for analyzing and storing data called TextStream. And that's not something that he was familiar with. And so that may have led to some issues with him not fully understanding the key cycles and how the odometer was measuring this. But if that does match up, it's important. But like I said, I prefer to go with the correlation because it's much more exact and it's not the kind of thing that is difficult to explain. The correlation between the TextStream data and John's phone data. So we know from John's phone data and from both from the GPS on it and the Waze that they were using to navigate to the house. We know that they missed the left-hand turn onto Fairview coming down Cedar Crest, so they had to do a 3-point turn. And she must have been angry at that point because she punched the gas during it, and that triggered the creation of an event. And then 8 minutes and 4 seconds later is the next event. And those are the only 2 events on her car from the time that she owned it. So that's a really powerful, it's really a bulletproof tool. All right, surveillance footage and blood alcohol extrapolation proved that Karen was highly intoxicated. Contemporaneous voicemails show that Karen O'Keefe had been fighting. Incriminatory statements and consciousness of guilt. Karen was the one who located the body from the back seat of a moving car in the dark, in the driving snow, buried in the snow, buried under the snow. She wasn't buried under the snow. Obviously, John was. Karen made a number of highly incriminatory statements to a variety of people the morning of John's body was found, including various paramedics, police officers, and civilians, including John's niece. This isn't an exhaustive list of all the evidence, but it's enough to make the point that the prosecution actually has a very strong prima facie case. Indeed, it's so strong that if you presented this case description to any criminal litigator outside of the context of this case, they would immediately assume that it was destined for a plea deal rather than a trial. So, again, this is a lawyer, and I don't know anything about who he is or she is. I don't know their background. But all of their articles have been extremely well written and suggest extensive experience and knowledge of the law. So let's just repeat that sentence. Indeed, it's so strong that if you presented this case description to any criminal litigator outside of the context of this case, they would immediately assume that it was destined for a plea deal rather than a trial. So that sounds like very compelling evidence. And you don't have to take my word for it that the evidence pointing to Karen's guilt is extensive. All the proof you need of that can be found in David Yannetti's first words from the trial. And this is interesting. From the fact that David Yannetti began with this, Karen Reed was framed. Now, I'm quite positive, he says, that in the entire history of criminal jurisprudence, no defense attorney has ever resorted to the "my client was framed" defense in response to a weak prosecution case. So, yeah, that's similar to what I said. If you can't fight the evidence, you challenge the police. So what he's saying here is if there was powerful evidence, if the actual physical and data evidence against Karen was weak, then you wouldn't need to resort to "my client was framed," which is a really difficult thing to prove. And no evidence literally ever has been put forward during the trial or any other time by this defense team that shows anybody else planted evidence, manufactured evidence. Nothing. All right. So the very fact that they've resorted to that, this lawyer is arguing, is a sign of just how strong the state's case is. He says, alleging that your client was framed is a last resort defense. The kind of defense you only fall back on when there's no other way to explain away all of the incriminating evidence. Right? That's worked at OJ. That doesn't mean no one has ever been framed for a crime, but inherent in the very concept of framing someone is that you plant evidence that strongly points to that person's guilt. If you're going to go to the effort and risk of framing someone for a crime, You do so with strong evidence. That's the whole point of the exercise. So, can we at least dispense with the silly notion that the Commonwealth's case is weak or that there's no evidence pointing to Karen's guilt? The evidence against Karen is so strong that even if she is acquitted, unless new and very compelling evidence comes to light, in other words, someone else confesses, no one else could possibly be charged with this crime. There would be built-in ironclad reasonable doubt with respect to anyone else. So that was from Anonymous, published on his Substack. Thank you, Anonymous. Not that you sent it to me, but glad to see it. And let's see. Tuesday has an article out. Let's see what she's talking about. So we'll do Tuesday's article. This is Tuesday Gazette. All right. So this is from Tuesday Gazette. The title is Did Karen Reid's team mislead the court? Briefing, defense admits to paying ARCA experts $23,000. Not going to lie, she says, I expected more from last week's hearing, but it ended up feeling like a 5-hour work meeting that could have easily been an email. Yeah. I think even the other side thought that. On top of that, we're now heading into a third day for the continuance of the hearing regarding the defense's relationship with the ARCA experts. I'm not actually clear if that's on tap to be discussed tomorrow. It's not clear, but there hasn't been a ruling on it, so it might be. It's vague at this point. Note, several places you can live stream on YouTube, Law and Crime, Court TV, or Yellow Cottage Style. Oh, thank you very much, Tuesday. And we only comment during the break. She won't see us on the screen during any of the hearing. Also, if you need to brush up on what the initial concerns are over at ARCA and the defense, you can read here from my last newsletter. Here are the highlights gathered from the last hearing. Defense attorney Robert Alessi spoke for the majority of the day in court. He started off by saying he will not obfuscate, and then he obfuscated the heck out of, it was funny. In fact, when the judge early on seemed to want to know one thing, she wanted to know, what was it that she asked him? I know one thing she asked him about was the rules of the protective order, but it wasn't that. There was something else. And he said, I'm going to get to that, Your Honor. And he never got to it. I can't remember what it is now. There was something that he didn't want to answer. So he didn't. It was a long-winded and not so scenic route to the main points, but he finally got there, sort of. Prosecutor Brennan filled in some gaps on billing and communication dates that Alessi didn't cover, but overall the picture was painted for us. Here are the main questions we all wanted clarity on. Did the defense pay ARCA? Yes. They paid the ARCA experts close to $24,000 last July. Despite Karen Reid supporters demanding last week that the expenses were only for travel, the defense admitted in court that they paid them for more than that. So yeah, look, Nick Rocco is part of the team. And if I was Nick, I'd be a little upset. Like, why are you telling me things that only a week later are disproved in court? So he was saying that they had the receipts and it just showed it was just travel. But we got the receipts last Tuesday and it was for more than that. So if they told him that, and I believe they did, I don't think he was lying. He should be saying, why are you people lying to me? You're sending me out on court TV to lie for you. I don't appreciate it. And it's not necessary, All right. Alessi states that they paid ARCA for their time, but tries to emphasize that it was not for their testimony. Technically, this is how all expert witnesses are paid, he said, for their time. It's literally the definition of hiring someone. So the semantics chosen here seem a bit disingenuous. Yeah, they were paid for spending multiple hours prepping with Karen's defense team. That's what you get. That's what they're paid for. What else would you be paid for? What do you think Rich Green is getting paid for? So he's paid for his prepping. He gets the bill for that. He gets the bill a lot, but he gets the bill for it. He pays for having to travel here and testify. I don't see I don't see anything different between what Rich Green was paid for and what the ARCA guys were paid for. The defense says they didn't know that they were expected to pay the experts until the bill was sent in July. That seems unlikely, right? I'm sure Tuesday would agree. When they received the bill, they reached out to the state attorney's office. I think what they reached out to was the U.S. attorney's office to see if they can make that payment. And they were told yes. The problem is the defense never disclosed this info to the court at all. In fact, a recent motion signed by the defense attorneys continued to mislead the court by claiming ARCA was unpaid. So that was a recent motion. So they were, they could try to play a fast one in the trial and say, we have not paid these guys anything, knowing that they were going to get billed and would pay them afterwards because they paid them with, no question asked. They didn't question the amount of the bill, and they just paid it, $24,000 in July. But to be able to try to say something like that after that, it's just plain dishonest. So a recent motion signed by the defense attorneys continued to mislead the court by claiming ARCA was unpaid. Since this last hearing, defense filed a correction on March 3rd that states the law clerk typed the misleading statement. Blame it on the butler. No, blame it on the law clerk, right? And I read that affidavit this morning. And that it meant to say that they were unpaid for the research and analysis. Despite this, the attorneys had signed off on it. There is no way that Alan Jackson, David Unetti, and forget her first name, Little, they all were aware. They all were aware. Because the thing is they're trying to present ARCA as independent, which they are not. And that's now clear. Now, I don't know what the remedy is in trial. I consulted an anonymous lawyer today on that, and he's dubious as to whether what I wanted to know is, could the judge instruct the lawyers not, if they're not allowed to discuss the feds, then they shouldn't be allowed to present ARCA as independent at this point. So my contention is that would be a fair solution, but I didn't know if it'd be legal. And he seems to think it probably would. He or she seems to think that it probably is not, because it could be something reversible. But most of the lawyers in this have seemed to also disagree with Judge Cannoni's approach of not allowing the defense to talk about the feds, not allowing either side to mention that the feds began this investigation. Now, I agree strongly, just on a principle of fairness, that the judge is doing the right thing on that, because when you tell a jury that the FBI was brought in to investigate the police, the investigators, the prosecutors, that's reasonable doubt right there, especially if you're not allowed to say that they found nothing, because they did find nothing. So, but if you can't say that, if all you can do is just say they did an investigation, it doesn't seem, it doesn't seem like it doesn't seem fair for the purpose of justice. So I don't know, but then that's counterbalanced by the general idea that you should be telling the jury accurately the truth as much as possible and giving them all the relevant details. So I don't know. It's an interesting case. All right. So did the defense break the federal protective order? It appears like they have. However, we'll need the final word on that from the judge. And actually, this is a problem too. The judge didn't even know what the protective order was. The protective order was not issued from her court. So even though the defense clearly broke the protective order, in my view, doesn't matter, because it was not one of her orders. Can she sanction them because they broke a federal protective order? Did that federal protective order have any binding power over her court? I don't know. I don't know. It seems like a stretch. We know the feds aren't going to enforce it. They would enforce it presumably if it was the state that was doing it, but they've chosen a side, as Hank Brennan described it. There's a tendency to pick teams, he said. And the U.S. Attorney's Office picked Karen for whatever reason. And once they pick a team, then that's it. And that's kind of what happens in life, right? Once you pick a team for whatever reason, now you're on that team, and you develop a confirmation bias and everything. And you're going to look the other way on their wrongdoing. It's just a natural human tendency. We see it obviously in politics, but it just really exists. We see it even in sports. I mean, it exists in everywhere. All right. So she goes on, the public doesn't have access to what the federal protective order says, but the attorneys have mentioned the content several times. So she's correct. Both David Yenny and Adam Lally mentioned it in the pretrial hearings last year. What we can gather from it is that nothing was to be discussed about the federal report outside of court, and prepping with the experts was specifically outlined as not allowed. And clearly the defense did. But they may have got a subtle hint. Now I can't prove this, what I'm going to say now, but they may have got a subtle hint from the U.S. Attorney's Office that, don't worry, guys, this rule doesn't apply to you. I mean, there's been enough shady stuff going on here regarding the U.S. Attorney's Office that's not unreasonable for me to say that, to speculate on that. There's too many weird shit that's happened. Okay, so let's continue with this is from Tuesday Gazette. There are billed hours from ARCA that started back on May 1st of last year, including phone calls between the ARCA expert Daniel Wolf and defense attorney Alan Jackson. The content of those calls is unknown, of course. They're not going to write down it. They're not going to memorialize. Alan Jackson's not going to memorialize it with a report outlining all the illegal prepping that they did. An outline was also provided from Wolf to Alan Jackson that was never shared with the prosecution until recently. There are also hours billed for, now I don't know, we have not, it's been shared recently, but we haven't seen it. There are also hours billed for prepping for both experts, but it is unclear as of right now if the prepping was independent or if it included the defense. Well, I mean, all indications are it included the defense. I mean, even Dr. Wolf was even given Alan Jackson a little advice about how to sidestep questions from the prosecution. I mean, yeah, it is what it is. So what we do know is Dr. Wolf showed extreme favoritism with the defense in those communications. Here are some of his quotes pulled from different moments. If you don't want me to say this, that's fine. Again, that's from Dr. Wolf. So that's what I'm talking about. Yes, I've realized in my testimony that I said it was 20 times when you have asked how many times I've been qualified for. I misrepresented the question, my fault. 11 trials, 7 depositions, not sure if you want me to clear that up. So that one's not so bad because he was allowed to discuss. The only thing that the defense was allowed to discuss was travel expenses and their qualifications. Just get a list of their qualifications. So I think it was okay. Obviously, you can tell from the language that Dr. Wolf is not at all independent. He's trying to help these guys out. He says, feel free to make whatever changes you feel necessary. So he's saying you guys can look at this list of my qualifications and make whatever changes you want. Why say that? Why say that if you're actually independent? Question number 3 from Tuesday is, did the defense mislead the court? Again, we have to wait for the judge to make that final conclusion. But I think it's fair to say that they were not forthcoming regarding their relationship and dealings with ARCA. Not only was the paid bill of near $24,000 never disclosed until the state's attorney emailed the defense and prosecution, but the hours billed began prior to the voir dire. Hours billed for ARCA's time. Hours billed. All right, so on 5/1, there was hours billed for ARCA's time, and on 6/9, there was also hours billed for ARCA's time, and then on 6/18, they billed for the voir dire. So that preparation began, at least in terms of what they were billing here, on May 1st, which is almost 2 months ahead of the voir dire. During the voir, I mean, you'll never be able to prove it, but I guarantee there was more calls than that. You can just tell from the way these guys were working with them. All right. During the voir dire and trial, The line of questioning from the defense may technically not be false. Have you met me face to face? Have you been paid to testify? So that was the line of questions that went in there. So again, this is Alan Jackson trying to suggest to the jury that these guys are not our experts. They're independent, which I think those questions should be banned. Just ask the questions about their conclusions. Just stick to the science, right? Stick to their science. Um, either you should be able to fully explore this in front of the jury, including the fact that there may have been bias on their part. There may have been bias on the U.S. Attorney's Office. You should be able to include perhaps even the fact the U.S. Attorney's Office closed their investigation. Or you should just be able to you present these experts and let's just hear their opinion and let their arguments stand in court. None of this bullshit about trying to present them as independent. But it clearly danced around the full truth. So they had not met face to face, but they talked on the phone multiple times. They had not been paid, but there was an expectation that they would, and they were promptly paid right after the trial. So Tuesday continues. I'm not sure what is left to discuss in the hearing, but I imagine that the judge has very direct questions she may be asking the attorneys to get to the heart of the issue. If she finds that the defense intentionally misled the court, she may send Alan Jackson and Elizabeth Little packing back to California. But it's hard to imagine she will do that. The trial is supposed to start in 4 weeks, and if Karen's attorneys get removed, it will likely be another 6 months for the second trial. And I don't think anyone wants that. So, I mean, I agree. And I think another really good point by Tuesday here is, so it seemed like the statements by the attorneys were done last Tuesday because they both got a couple of bites at the apple. So I'm wondering what was left to continue here. But Tuesday raises a good point that it may be that the judge will now have questions. So that's important. So maybe that's where we'll begin on Tuesday. All right. Let's hope Judge Cannone finds the best solution for all of this while also moving things along. If this courtroom drama isn't enough, there were some big motions and oppositions filed recently. The defense filed their motion to dismiss for egregious government misconduct, and the prosecution filed their opposition. I'm not entirely sure when this will be argued, but I will update you when it is. I believe that's to be argued tomorrow, isn't it? All right. So thank you. Well, I'm not saying thank you. She didn't send it to me, but great job, Tuesday. All right. So I haven't been seeing chat while I was reading those. Is Tuesday by any chance here? Maybe she can answer some questions on that in chat. Is Tuesday here today? I'm scrolling through chat. Don't see her. So, okay. So I don't know, the federal involvement in this case makes everything unique, and it's really difficult even for lawyers that you talk to. So Jules, I don't think they're going to allow the extension. I don't think there was enough there as a basis for that. So I don't know. I don't think they will. But I do believe the motion to dismiss is going nowhere. Not that there aren't, in theory, legitimate beefs about this weird piecemeal release of evidence, but there's no reason to indicate that. So maybe Friday. Okay, if they extend it to Friday, that makes sense, Jules. There's no reason to indicate that the evidence was exculpatory. In fact, it tends to be inculpatory. It hurts Karen. And in addition, there's no indication that evidence was deliberately withheld from the defense. So I don't see anything in there as a basis for dismissal. And the remedy is too severe for basically video that was in a normal investigation considered to be utterly meaningless. Like I've said many times, we haven't seen any video of the troopers delivering the evidence to the district attorney's office, to the evidence room, right? That doesn't mean that evidence doesn't exist or didn't exist. It just means it's not normal. When the defense says to preserve all video data, nobody's thinking about the evidence that was brought to the evidence room and every aspect of the investigation in every stage and the vehicle being towed into the Sally Port. Nobody would have thought of that. Nobody would. It's not reasonable. Nobody would have ever considered something like that. So, no, there's no way there's going to be a dismissal here, and it seems to be, while part of it was redacted, the whole thing on the dismissed juror is crazy. So, all right, let's see what the kerfuffle is in chat. How you guys doing in chat? Is everybody having fun, being friendly? Let's not get Tom going, man. You don't want him to bring down the hammer. So, Wicked Smart, thank you very much for the contribution. Funny Bunny. So they paid the FBI $9,000 for their research and paid $23,000 for travel expense. I am in the wrong business. Yep. Although, to be granted, they did have to get their PhD. So but I don't think when you go to study science and get a PhD in college, if you start a career in science, I don't think you're saying, geez, when I grow up, I want to be an accident reconstructionist that testifies for insurance companies for a living, because that's what they do. You don't start out that way. If you go into science, you probably are interested in science. Why didn't you end up in science? It's a question. And then Funny Bunny corrects it. Correction, FBI paid ARCA $9,000 for the research, and the defense paid the $23,000 for the travel and the prep. Yeah. All right. So I'll just look, and I don't think I'm not going to do a long show today. Got to be on in the morning. But thank you. I'll take some questions for a little bit. So for many years, part of my life was the St. Patrick's Day parade in Worcester. I worked at a bar, then I managed a bar, then I owned a bar up the street, all on Park Ave, where the parade is. And that parade in Worcester always comes a week before the parade in Boston. So I'm assuming that the parade is this coming Sunday. Well, the reason I mention it is because that is from someone that sometimes you might have a snowstorm right before the parade and you're worried about snow on the sidewalks and things like that. And generally the weather starts to make its first solid movement towards spring within a day or two of that parade day, generally. So the weather should be looking up. Just wanted to say something, something to keep that in mind. I also want to say this too, because this came up recently with people. I don't want to get into the details of it, but that people that on the anti-Karen side that disagree with some of the things that I say. Great. We should all have our own opinions. And as long as opinions are sincere and reasonably well argued, everybody should have their own opinion. Nobody wants to live in an echo chamber. Nobody leads this thing here. I don't lead it. Hank Brennan leads it. I'm not a leader. I'm just someone giving my opinion. And on some things I'll be right and some things I'll be wrong. And so I always look forward to seeing your opinions. And if you have a stronger argument, you can convince me. So there is no leader in this. It's not me. It's not Kate. It's not anybody. So I'm not against. I encourage anybody to disagree with me if That's what they, if that's what, if they feel strong, more strongly about an argument that they have. Just want to make sure that that's clear all the time. Uh, your opinion, always have your own opinion. You know, I've changed my opinion on different things in this case. So certainly I've been wrong. Either I was wrong then or I'm wrong now. But I mean, you know, that's um that's important. So yes, it would seem that, well, that was Gene Doctors, that was in the motion last week, or the counter to the state's counter to the motion to dismiss, where they had collected Sallyport video from a month before John's death, and it too was inverted. That's just how it recorded. So I mean, this question about did John's phone move at 6:04 a.m. We saw no evidence of that. Rich Green didn't try to make any argument about that. The defense didn't try to make any argument about that. I don't think there's any need at this point to dig into things that certainly have a very mundane explanation. When it comes, do we need to bring in a GPS expert into the trial just to explain something like that? Because did the phone move a little bit under John as they were trying, as when the women arrived? Is that enough to cause that phone to reach out, um, and check its GPS position? Because the phone thinks it's moving, right? Even if it just moved a little bit. And so I think it's something like that. There's no indication that that phone moved around or there's steps. We have to get into the intricacies of how this actually works. So GPS comes with a margin of error. Now, that margin of error is always measurable from second to second. And so, what was the exact margin of error while John was lying on that phone? Now, the phone, if it, let's say the margin of error is the usual 15 feet. If John was walking within that 15 feet circle, it's going to have, it's going to be very imprecise about measuring how far John walked. So and if the phone just moves a centimeter within that circle, that could be enough that someone misinterpreting that data, perhaps intentionally, could say, oh, he walked 15 feet, but it was just the margin of error. But I mean, I'm not giving you a detailed explanation because it never struck me as something interesting. The phone moved when he was rescued. That's it. Tom will not be attending this year's Worcester St. Patrick's Day parade. I think it's been years since Tom has attended one, and because he is leaving the country. Tom is taking a lovely vacation in Ukraine. He'll be on the front line. I'm kidding. A few years ago, he might have been tempted. But obviously, I hope he enjoys a well-deserved vacation. Do you think the judge will entertain the defense? And hi, Hillbilly. Do you think the judge will entertain the defense filing for her to reconsider the video metadata she already denied? We'll see the arguments on that, but I'm going to say probably not. This is getting this. I can understand the argument by the defense because of the unusual way that this data was revealed piecemeal. They want to say, all right, so what went on here? Was any video deleted? But there's no indication of anything irregular or any actual foul play. There's no indication that there was anything actually exculpatory in that data. So the judge is not going to let that slow up the trial. No way. I don't know that the phone was in his back pocket, James. It might have been, but it was found underneath them, is all we know. So did it fall out as he landed? Did it fall out when they picked him up? When the first responders picked him up? I don't know, and I don't think anybody knows. Thank you, Joe. You gotta understand something else about. I see a lot of questions about Vinny Politan because he did an interview with Melanie Little. Vinny's, we're me and many of us here in chat. This is the case that we're following, but he's covering a whole bunch of different cases for the channel. So he's probably not watching much of the trial. He's probably getting updates from other people. Um, and just in general, he wouldn't have an in-depth understanding of the evidence because he's doing other things. He's covering a lot of cases. He's a professional entertainer for a TV channel. A lot of preparation goes into that. So um, I just think we have to keep that in mind. That's all. Vinny, I saw part of that interview, and he did seem to believe that the most logical explanation, Karen was drunk. She's at the scene where John's phone last moved, at least within that time range or a few minutes before. And the logic of that is pretty simple and hard to get around. Let me just stretch for a little bit and have another sip of coffee. Ugh. Okay. Yeah, Melanie was definitely not too happy about that. No question. So, out of her respect for Vinny, she dialed back some of her own. But yeah, we all know how Melanie is on this. And I didn't hear the whole interview, but I heard enough for Melanie to still talk about 227 as though it's a fact. It's hard for me to take people seriously like that. Maybe she still thinks the belt is missing. Maybe she still thinks the hat is missing. Who knows what she thinks? I mean, she's not really pursuing the truth. She's pursuing clicks and views. Jules' court starts tomorrow at 9. I'll be on at 8:30. I'm not sure who's going to be with me. I've extended it to Kate, as always, to Matt, Boundless Millennial, to Drunken Turkeys, Daniel, and to Jen Coffenaffer. Jen will be here with us Wednesday and Friday, but I don't think Jen Coffenaffer will be with us tomorrow. And I'm not sure about the others. So Macy's going to sleep. All right. Good night, Macy. We'll see you in the morning. Thank you very much and good to see you. Thanks for joining us. So we'll see if it's just me, Daniel has his wound treatments on Tuesday from his dog bite. So people will jump in when they can jump in. I missed so let's see. Michael McCarthy I'm not sure what question he was answered, and he said we don't know. So I missed the question though. So Penny has a good point. Oops. Like, oops, the thing moved. All right. Penny Fortin says if the phone stopped moving at 12:32 and then later found underneath John's body, how can the defense say he entered the house? It's crazy. They just want you to ignore things, though. GPS, which is extremely accurate, shows that John's phone never went in the house. But they don't try to explain how the phone got where it did, and they don't think they want to ignore that anyways because they want to try to say that the phone was going up and downstairs, which it was not. So, will Judge Canoni ask for an accounting of all conversations between the defense and ARCA? Well, they won't be able to account for phone calls. And that's why lawyers, when they do things that they don't want to be entered into discovery, they do it on the phone or in person. Julie Grant does a great job, and Julie Grant does a great job with her opening statements. I assume she writes them himself, but they're always brilliant. Now, that said, there's a role for Vinny. Julie will have on. I don't know if Julie ever has on guests that are from the other side, and I do think that in general, there's a role to have balance on both sides, even if one side is reporting things to something in some ways are irresponsible. I think a lot of the stuff that Nick says on that program is irresponsible. He may believe them. I'm not trying to, it's not a personal shot. I'm just, you know, to constantly be accusing innocent people despite no evidence is irresponsible. But that said, I think the format of having a couple of lawyers, one that's pro defense, one that's pro prosecution, and a couple of insiders, as they like to call us, one that's pro one side, I think there's a value in that, because it's one of the dangers. I've talked about this before, but all the time is echo chambers, right? We see this in politics, science, everything, and everybody's just in with their group, and they only hear what their group wants to hear, and that's it. So they don't even. So this is the thing. Like when I was on with Nurse Kim, that was a couple weeks after the trial, and with Cullinane, they didn't even know that there was an explanation for why the car was towed to the Sallyport. They didn't even know it. So when you live in echo chambers, you don't know the ordinary explanations for things. And that's a problem, so I don't want that here either. I don't want us to have an echo chamber where we only hear everything from one side, because then we're going to miss things. I'm going to miss things. And I don't want to do that. I want to be able to see all the objective evidence, even evidence that I might not like in any case. Any case that we do. It's important. It's important to avoid echo chambers. So Tully said thigh. I don't know what that means. I'm sorry, Maui. I don't really understand what you mean. That Tully said thigh. I don't know what that means. Or tie, or actually the way you spelled it. I don't know what the emails are about. I'm assuming that they're probably the emails between the defense and ARCA from about last spring, but not sure. Ashley and I said, good luck tomorrow at your doctor's appointment. And yes, so I do try to look at everything both sides. Again, I'll get it wrong, of course, but I'm always going to try to look at things from both sides. I don't know what Christy Brinkley looks like now. I haven't seen her in a long time, but the Christy Brinkley that I remember, yeah, I don't see a resemblance, but I think Nurse Kim believes it, but and again, it's not just for donos for everybody here. I don't know how much money I don't know if she makes any money of this. I really have no idea. For some people, there's a social reward. Think of all the friendships that some of these people have formed through this. Look, I formed friendships through covering this case too. People that I hope to stay friends with after the case is over. So I get it. I get it. And for those people that were out demonstrating since early on and are still out there rain and shine all the time, you know, I get that there's a great social benefit in that. So it's very difficult for those people to question things now at this point. So, but you have to try. You have to try to look objectively at things in life. Yeah, right. The belt is still missing. It's missing again. They showed it at trial, but now it's missing again. Oh, Kevin, I mean, Ken, you're the same age as me. I'm 58 too. Thank you, friend. But let's a little bit of a joke once in a while, but let's try not to focus on how people look. I have to say that, don't I? But even if I was this handsome, dapper young man, I would say that. Let's let's focus on the evidence, the arguments, the behavior. 59. Ken turns 59 in March. I turn 59 in May. So you're older than me, dude, by a couple months. Penny 8 is also 58, although she has a question mark. So Penny Forden is not sure if she's 58. That's okay though. Well, J Ray, I always say nice things about you, but that's not very nice. I know you didn't mean it on nice, basically, Kevin. I thought you were old, but you're only 2 years older than my boyfriend. I guess you're both old. So you're saying I looked older than I look. Than I look older than I am. And Penny turns 59 in April. So so March, April, and then May. Happy birthday to everybody. Joe says you are as old as the person you are feeling. Well, you could get in trouble for that. But you're a woman, so you should be okay. But if I said something like that, man, if a guy says something like that, you get in trouble. Yeah, 21 in dog years, Jen. No, Joe is. I know Joe has a son that can almost dunk a basketball, so she's probably a little older than 21. Thank you, Lisa. Let's see if before I don't want to go on too much, but I don't want to shortchange it. Just there's not much new to go over tonight, and I don't really feel like going over clips. So let's just look and see if there's anything new on Twitter in terms of. All right, so here's an interesting post from Nebercracker. The FBI and the U.S. Attorney's Office have officially closed their investigation into whatever they were investigating with the Norfolk County DA and subsequently the witnesses in the Commonwealth versus Karen. And surprise, surprise, after all the noise, all the dramatic claims, all the internet sleuthing. What do they find? Absolutely nothing. No federal crime. So I want to also, so Vinny said today that on that interview with Melanie Little, that the feds didn't seem to do much of an investigation in there. But I don't really understand why he would say that. I don't know what I'm not saying he's wrong. I don't know what the basis is. And I guess compared to what, right? So it's not like they just did a superficial investigation, because they went through the expense. I mean, first of all, the investigation was 2 years long. They went through the expense of impaneling a federal grand jury. So that's a lot. They brought in a lot of witnesses. They got a lot of data. They got the content of messages from pretty much everyone in the house. So that means probable cause. So I think it's a pretty thorough investigation they did. We don't know. It's sealed. So we only know what was revealed in the trial, which wasn't much. See, the only thing that the defense could really go at in trial was they could look at the grand jury testimony and use that as a basis for questioning the witnesses. Other than that, they weren't allowed to reveal anything. They could put the ARCA guys on the stand. But it's not like, let's say the feds found, let's say they did get geofence data and it showed who was in the house. Adam Lally can't say, oh, by the way, I just want to inform the jury, I read on page 1700 of the federal report that XYZ. No, he can't do that. Any evidence has to be introduced through a witness. So what's he going to do? Bring in an FBI agent? I mean, or bring in someone from the U.S. Attorney's Office? They aren't going to honor it. So so we don't know exactly. And that was, because of the protective order, they weren't allowed to talk about what was in that report. So we don't know. We get just tiny little bits that were released by David Yannetti last spring, and then by Hank Brennan this year. But that's it. We don't really know what they got. So I'm not sure why Vinny says that. We do know that they got the phone communications. We do know that they did a federal grand jury. We do know they hired ARCA. We do know they hired a couple of dog bite experts or something similar to that. So, but beyond, so they did. I feel like they did a fairly extensive investigation, especially given that they found nothing. If you find something, then you keep digging harder, right? But let's put it this way. Let's compare it to Sandra Birchmore. It seems like they did more here in terms of resources and time than they did to investigate Sandra Birchmore. With Sandra Birchmore, they were able to look through the messages that the state police had shared with the Stoughton police task force on this case. That was shared with the feds, and the feds, there was, I guess, this confusing massive messages. We'll have to find out more on this. The most information we got from was a Good Boston Globe article a couple months ago. And it seems they were able to analyze that and find messages that Farwell thought were destroyed, but they were able to get them. And other than that, they did bring in their own for medical examiner. I'm sorry, I couldn't think of it. They brought in their own medical examiner to look at the evidence. Now, they didn't have the body to look at, but they could look at the rest of the evidence that was revealed in the autopsy, and they came to a different conclusion than the state's medical examiner, the medical examiner concluded it was a suicide. They concluded it was not, and they listed their reason why. But other than that, we don't know. Maybe they did a lot more than we know, but it seems that they didn't do an extensive investigation, and yet they were able to come to a conclusion here and charge Farwell. So they did great work. But it seems like they had to do a lot less work than they did in the Karen Reed case. So I don't know what would be the basis for saying, I forget exactly how he worded it, but that they didn't do a very deep investigation or something like that. If I just, maybe you guys remember if you watch it. I don't remember exactly how he worded it, but I do disagree with that. Mama Gigi says, "Do you remember before the trial?" And the judge got the 3,000 pages, and she said, "Now I know how the investigation was started. That needs to be disclosed." Yeah, I mean, she did say that, and we don't know. Thank you, Jezebel. Um, we don't. We all we know is from what Karen has told sources, and that's that she and her attorneys walked into then first assistant U.S. attorney Josh Levy. Must have Yannetti or somebody had to pull to get a meeting. You or I couldn't get a meeting. Regular lawyers couldn't get a meeting. They got a meeting, and they pitched the fact that this was a conspiracy to Josh Levy, and it seems to have been enough. They convinced him. They launched an investigation. So, but what did they convince him with? What did they tell him? Because the weird data found by Rich Green didn't exist yet. Stair climbing in 227 that didn't even exist yet. Jen, I don't really know much about the motions today. I mean, I glanced at them. They weren't really of much interest to me. So just being honest, nothing was really clear in them, or nothing was new. It was just routine stuff. Jean says that Rita has been MIA. Yeah, she wasn't happy about not being invited to the fundraiser. I don't blame her. All right. So Michael McCarthy says the state has its own lawyers paid by taxpayers. Is it a waste to then hire another outside lawyer to do the job? In my view, no. Not if you think that that is the best way to get justice. Um, but I know for a fact, and you just have to sometimes accept my word, that they couldn't get any of the other prosecutors to take this on or even to help Adam Lally because of the Turtle Boy crowd. And this is the same reason that we've had this problem with the state had trouble finding lawyers that were willing to take on the special prosecution role to go after Turtle Boy. Everybody's afraid that that mob is going to smear somebody in their, either them or someone in their family with dirt. And so this has made them all afraid. It's a terrible state of affairs. People that, I don't know if Rainey's been here tonight. You really have to understand what that crowd is. And it's a false equivalency to try to think that that goes on the other side of the aisle. Not that there aren't people that cross a line on the other side sometimes, but it really is, apples and oranges. That turtle crowd is knowingly trying to destroy anybody that opposes them in even the slightest way, even as questions. They're trying to destroy them with the threat of social media smear. That's what they do. And it's something that Turtle Boy was doing 10 years ago. So it's not new, but it's really on full display here. And it's gotten big enough that it's terrified lawyers for not wanting to jump out against him. Now, Hank Brennan was made of different stuff. And he said, I'm not afraid of that. And look, when he was announced as special prosecutor, within an hour, Turtle Boy put out where his wife worked to try to dox her. So, I mean, and Maureen points out that special prosecutors are pretty normal, especially with a retrial. And I didn't know that. So thank you, Maureen. That's very good. And it makes sense too, right? So because the special prosecutor gets to come in and build on the real nuts and bolts work, to use the expression I used earlier, that goes on. So if I'm dating 65 CJ, so you must work for the Norfolk County DA's office, because somebody earlier said that's who I'm dating or something like that. I don't know if they used the word dating. They used something a little more salacious. Danny says he spoke to Alan Jackson. All right. So I'm definitely 100% going to end this at 9:30. So we'll get 6 more minutes to take on questions, and then I'll see everybody in the morning. Thank you very much to the great moderators, Thomas Fleming and Joe. So thank you guys. I wouldn't say, Kenny, that it does. The fact that the ARCA guys found nothing doesn't prove that the ARCA guys were wrong. The fact that the feds found nothing, but it does add to that opening because to that conclude, you could conclude that that really discredits ARCA quite a bit because, and thank you, Thrift Check, because this case is an either or. Either there was a very significant cover up and conspiracy to plant evidence, or Karen's Lexus struck John. There's no real middle area. It's not like some other car did it. There's no other weird theory that could have happened. People have been trying to explore that for a while. Like, is there some way that it had nothing to do with the people in the house, but maybe it had nothing to do with Karen? No, there's no way. Look, her taillight pieces were found at the scene. So unless somebody planted them, 2 plus 2, it is what it is. So the fact that the feds found no conspiracy, so that does tend to definitely, it's a pretty big blow to the ARCA guys trying to say that John wasn't struck by a vehicle. And I would think that as much as Dr. Wolf seemed to feel like a hero to that crowd back then, he probably feels kind of embarrassed now professionally, right? Because by now I presume that state has sent him the tech stream vehicle data. Those guys are experts on tech stream vehicle data. So if they hire him now, is he going to dig in his heels? Is he going to find some way to ignore that vehicle data? I don't know. Yes, Penny, it's very difficult to prove something negative, right? I just want to say, too, to the people that send me emails, I open every one. Occasionally, if I'm opening it on the phone, sometimes people send me emails and I open it while I'm on the phone talking to someone, and then I forget to reply. Or if somebody sends me an email that is really, somebody sent me some dirt stuff on Turtle Boy again recently, and I'm not interested in it, so I'm not going to reply to it. Danny says the conspiracy is not logical and not logically possible. And this is true. And this is the thing. So you have to start out with, once you know that the physical pieces of the Lexus were found at the scene, among other things like the hair and the pieces on John's clothing. But once you know that, you're like, all right, this is an either or. Either there's a conspiracy or Karen did it. And once you realize how there was no time to plant that evidence, there was no access to the vehicle, and how many other ways that it just doesn't logically make sense. Like, why are the troopers, when they leave the McCabe house at about, say, 11 or 11:30 in the morning, why don't they go to the Lexus? If job one is to plant evidence, is to tamper with it and then plant evidence, they don't do that. So there's just so many other, every way you run into a logic angle here, it doesn't make sense. Why do they take John out still alive and put him on their own lawn to die? Why do they tell the McCabe's ahead of time that they're going to do that? It's just so many aspects of this theory make such awful sense that it's stunning. It really is. You're trying to be so hard to be respectful, but it's stunning that actual people walking around driving vehicles think this after seeing. I mean, I can understand people thinking this if they just hear the stuff that's made to sound weird by the turtle crowd. But if you actually reach out, if you actually look at the evidence and try to get it from the other side, and you still believe that there's a conspiracy here, it bothers me that you're out voting and driving a vehicle. I feel like there's a danger to the public. Maybe that's unfair to say that, but there's something not adding up in the way your mind is working. Oh, so we have reached 9:30. So, all right, good night, guys. Thank you very much. And again, I hope that wasn't offensive. I'm not trying to, I know there are good people that believe in this conspiracy. So, doing the best we can to be respectful, but it really is just sometimes hard on certain aspects of their beliefs. So, but I respect all religions. So, have a good night, everybody. See you tomorrow at 8:30.